Good afternoon, everybody. Goodness. I'm Brian Tully. Welcome to our second annual Medicaid update webinar. You've been with us before, so what we're going to do is give a few minutes for people to log on, and then we will join you back shortly. So please bear with us for a moment. All right, everybody, welcome back. My name again is Brian Tully. I am the founder and managing partner here at Tully Law Group. We are grateful you're here to join us today. We're going to be covering today the second annual Medicaid update. We did this last year, fortunately, and it's an important topic because Medicaid is one of the more confusing issues that we as New Yorkers encounter each and every day in our practice and in helping our families and caregivers and so forth. So we are joined today, just like last year at our first annual, we're joined by Dennis McCoy. Dennis McCoy, however, this year, he's now a partner at our firm here at Tully Law Group, and he is the director of Medicaid for our clients. He concentrates his practice in the areas of Medicaid planning and eligibility, which of course encounters all of the concerns we're going to be talking about today during the Medicaid application process. He also focuses on trust planning and asset protection and eligibility. His legal skills, however, and gratefully, are augmented by his health science background from a previous career, which he always and effectively uses to help the clients securing necessary critical healthcare services. And our special guest today is Jim Sluder. Jim, for the second time, is joining us to talk about our Medicaid updates. He is the Medicaid director for Suffolk County Department of Social Services. He has spent over 20 years working in the Medicaid division. He previously served as the head of training and procedures for Medicaid in Suffolk County, where he conducted in-house trainings as well as several community advocacy programs throughout Suffolk County, like we're doing today. And we're grateful that you're here, Jim. So thank you very much. It's great to see you again. Wait, I think you're on. Are you there? I didn't hear you.
I am here.
There we go. Good. So thank you. And as always, Dennis, good to see you again, even though you're just around the hall, down the hall. All right. So let's get into this. So the real concern, the real reality that's been building up for the last 4 years is going to be our first topic of discussion, and that is the idea of a look back period for community home care services. And I'd love to say we're going to have black and white concrete answers and direction, but as Jim will share in his own way, it's a difficult field because it's not just him making these decisions. There's layer upon layer. So Dennis and Jim, if we could talk about this a little bit, where do we stand now over these last 4 years with the idea of a 30-month look back for home care?
Sure. So I'll jump in first, and I think Dennis has some information on it too. just a little short background. So this was discussed that it was going to be implemented. It seems like for forever now, but it's probably only been a couple years. It was never implemented. It's been talked about, and then we had public health emergency, COVID-19 set in. It's been delayed. So the last information that we've received is that it is still potentially on the table, but with no implementation date. We are still in what we're calling the unwind period from the public health emergency, which has some special rules involved, a relaxing of some rules for Medicaid. And until we come out of that, they're not implementing anything more, what we could call more restrictive. So that's officially all we've been told, which is a lovely shade of gray, that to be continued, right? It's not going in at any definitive date. Please hold. That's what we know.
Got it. Now, all right, so I'm not going to push it too much, but do we think that means this year? Do we think that means next year, or we really just don't know?
The unwind protocols have been extended until the end of this year, which I feel comfortable connecting the dots and saying we're not going to see it this year. I could be wrong about that, but I think it's a safe assumption. I hate to make an assumption, but I feel like we're not going to see it during this calendar year unless something changes. We'll leave it at that.
Okay, fair. Now, Dennis, I know you've been following this very intently, of course, for our clients and eligibility and timing of applications. So talk to me about it from your perspective, and also a little research you've been doing on what Albany's working on.
Well, at this point, as Jim said, there's really nothing in concrete of when it's going to happen. And from our perspective, any eligibility worker that I've spoken to over the past year, there's no even talk about it amongst them. So it looks like there's a lot of regulation that has to be drafted and approved first before you even get there. And I spoke to Jim about this the other day. There is a Senate bill right now that's trying to eliminate the 30-month look back. That's being reviewed currently. It's not passed, but it's in the Senate. Whether it'll get passed, I don't know, but they're trying to eliminate the 30-day book. There's senators that believe the 30-month look back is cumbersome, it's unnecessary, and they want to eliminate it. Whether they'll get traction and actually get passed, I don't know. So there's a lot of stuff going on. The best I could say right now is it's just not going to be implemented, as Jim said. And I don't see any way that's going to be implemented anytime soon, especially not this year. I agree with Jim on that. I don't see how it's even possible.
Right, this year.
Yeah,
There's too much to do.
Too many regulations to draft.
Right. So from our perspective in helping clients and helping families, then we still gratefully have zero look back for home care for the time being. It is still out there as a potential threat down the road, as we've just covered. Now along that vein of talking about Albany for a moment, we can't have a discussion about home care without using those 4 letters, MLTC. So not 4-letter word, 4 letters. So the 4 letters of an MLTC. So we've been working within a managed long-term care program for some time at this point. And I know, Dennis, Albany, there's something going on up there also. So what else have you found out about that?
Well, there is another bill also drafted. That's the Senate. It's New York Senate, of course, trying to return to a fee-for-service model and do away with managed long-term care plans. That's really in its infant stages right now. It has been drafted. It is in the Senate. It hasn't passed any hurdles just yet. Whether it will get passed, I don't know, because New York is so entrenched in managed long-term care now. It's just what we're used to since 2012. And to unwind that is not going to be so easy to do. But there's a lot of complaints about managed long-term care plans and how they work and how they operate and how they try and reduce hours. So advocacy is very important when you have a managed long-term care plan,
right?
To try and advocate for the hours to keep them the same.
Right, Jim. Any insight on that?
No. Unlike the 30-month look back, which the state has acknowledged to Medicaid directors is always looming and could still, and they acknowledge that it's been delayed. This has not been mentioned at all. I have heard a rumbling the same as Dennis, not connected to my employment at all, but just that exactly what Dennis said. But we have not had any mention of this change. And I agree, I don't see how they put the genie back in the bottle, so to speak.
Yeah,
We're
right,
very entrenched in that. It would be a big change.
right, right. And Dennis, if it was ever to happen, is it going to be, I mean, this is just speculation, so probably not worth going down the road too far, but the
Yeah.
whole other fee for service option, is there another entity involved? I don't know. Let's just see what happens.
Yeah, that's the best they could do, because right now, I don't even know the fee for service, the way the bill was drafted, it was so bare bones that they spoke of fee for service, but I don't know if the state was doing the fee for service anymore. So I don't know if you'd have another private entity just taking over the whole program instead of a managed long-term care plan. So really, it's got to be fleshed out much more. It
Sure.
just shows that there's a general disdain for managed long-term care plans, not for the program, but for how the managed long-term care plans operate at this point. The program
Mm.
might be perfectly fine, they're just not following it.
Got it.
That's
Got
the
it. Understood. So for the benefit of our viewers, because I'm getting a couple questions in the chat box, and that's fine. We will try to get to questions later, depending on time and how long it takes for us to go through our content. And another question was, is there a PowerPoint to follow? And no, we're not providing a PowerPoint today because this is the Medicaid update. It's a discussion as to what's going on as best as we can detail and Jim can as far as Medicaid benefits at this point in New York and perhaps even more so in Suffolk. Now, another topic, shifting gears, because those are on hold, and as we talked about very specifically, there's a delay. We just don't know for how long as far as the look back period. Another conversation, staying within the home care world, is dealing with what's called an immediate need application. So an immediate need process, as I share with clients every day, is a way to deal directly with the county and ultimately work with the MLTC in the future. So Jim, actually, let's start with Dennis first, Jim, if you don't mind. So Dennis, looking at this, there are still care assessments that are required in an immediate need circumstance. So get into that a little bit for us, and then we'll get Jim's
Right.
input.
When you file a immediate need application, the first assessments that are done for home care is something called NYIA, New York Independent Assessors.
Right.
There's two assessments with regard to that. And the purpose of those assessments is to determine if you are eligible to get home care. They don't determine hours at those assessment levels. And that takes a little while to actually get set up because it seems that they're very backlogged, and it was originally implemented where the Department of Social Services nursing unit would call NYIA and set up a three-way conversation to make an appointment for those assessments. But that becomes so cumbersome that the hold times were 3 and 4 hours just to get the assessment appointment. So then it went back to the consumer to try and make that appointment and get Department of Social Services involved in it as well and get the assessments done. Because at that point, the local Department of Social Services is not involved in the assessment. It's NYA, it's independent assessor. So they assess the hours. After the two assessments are done, then it will go, in the need case, it'll go back to the county, whatever agency it is, the nursing unit, and they'll do an actual home care or Zoom assessment as it may be. Most of them are just home care or home visits. And they assess how many hours that a consumer needs, and they'll go through the approval process. So there are 3 assessments to start before you get home care.
Right. Now, how do you want to go with this as far as the concern? What do you want Jim to start addressing?
The concern is, and the question that I want to pose to Jim is, the referral process has been, every county does their own take on it, and you can only speak of Suffolk County, but from what I understood through the regulations, the county was supposed to make that first outreach to NYA, but I think that wasn't happening. And secondly, when the NYIA assessments are done, do they refer it back to the Department of Social Services local for their nurses to reach out to a client to arrange for that last nurse assessment? So that's where it gets clunky.
Mm. Jim, what are your thoughts on? Yeah.
All right, so I think I'll address it all somehow in what I'm about to go through. So, all right, so with and we're talking specifically about this immediate needs process, which is the majority of what we see these days. The state's guidelines were originally set up when they implemented this independent assessor, that for immediate needs cases, there was to be a 3-way call between the consumer, the Department of Social Services, and the independent assessor for the purpose of just scheduling. That does seem redundant In many instances, it's a call that we don't all need to be a part of just to set up scheduling. So we've kind of modeled what we're doing to just keep every door open and what works the best. So when we receive information, and I'm vague there, just saying information, whether it be from our staff telling us they received an application for someone that has an immediate need that is looking for home care, or the consumer themselves contacting our nursing staff to say, I have an immediate need. So either way, we reach out. So our first thing that we're going to check for is, do they have an appointment for a practitioner order and the UAS assessment? And that's the two pieces that I think we non-clinical people refer to as the two assessments. The state argues it's one assessment and something else. It's two assessments, right? We'll make sure they have that. If that's already scheduled or it exists, we take it from there, we proceed, we'll do what needs to get done. If they have not, we refer them to Maximus, the independent assessor, to schedule those two appointments. If the consumer is fine or happy with just making that call and doing that scheduling themselves, which often they are because they'll do it on their own time and make that schedule, that's the path we send them on. If they need assistance with that, well, we're certainly available to keep them on the line, have the three-way call, facilitate that scheduling if we can, and make sure that that happens. So either way, we're getting them where they need to go. And so Dennis, the answer when we talked yesterday was, well, which process are we following? The answer is yes. We're following whichever process works for the consumer that's going to get the job done quickest, because we're in those guidelines, right? We have to get it done. Second part of that, what happens after that's all set up? And the answer still kind of is whatever needs to happen. If a consumer comes back to us and says it's done, then we'll actively get that paperwork and go to the next step. Otherwise, we do get notified from the independent assessor periodically. It could be daily, actually, I'm not 100% certain. Here's paperwork that was completed, and then we pick up from there to do what the three of us would refer to as the third assessment. The state would say it's not, but where our nurse then picks up the pieces and does that care plan. So that's the three assessments, and it does happen, in a monitored timeframe, put it that way. We keep it moving as much as we can.
Right. So Dennis, what do we actually see as that time frame practically?
Well, I think the backlog is not so much the county, but I think it's more NYIA is putting the backlog, but it still gets done. It depends case by case, but I would say on average, they're trying to stay close to their 14-day turnaround time as much as they can. And it also depends on the availability of the client, maybe the doctor's appointments or whatever. So there is give and take, and a family member that wants to be present. So it's very hard to pinpoint it, but the calls, I just wanted to make sure that even the consumers listening know that sometimes you will have to get involved and take over and make those phone calls and make those appointments, like our office does and gets involved as well. So New York, NYIA is New York Independent Assessor. It's a organization that actually does, I'm looking at one of the questions that came up, organization that actually does those preliminary assessments to determine whether the consumer is eligible for Medicaid services in their home. They talk about ADLs and what kind of services that you need and make sure you qualify before they burden the county or local county with an assessment for something you don't qualify for in the first place. And maybe there's some ultimate tie-in with the look-back period if that was ever going to happen, because they would be doing those assessments prior to the local county member doing, county worker doing a 30-month look-back. So maybe there's some tie-in there, I don't know. But this is the system that we have. We try and make it work as best we can. And immediate needs, it has slowed down prior to NYIA assessments. It has definitely slowed down because there's 2 extra assessments that we didn't have prior to that. So, but we move along as fast as we can.
Yeah. So in our position as counsel and representing families going through these application procedures, we find it critical that these assessments are of course with the family, but also with what we call our elder care coordinators. So from our registered nurse to our geriatric social workers, as these assessments are happening, the way we structure it and the way we help our families through the process is we're certainly going to be advocating with the family during the assessments to help get through the first one and the second one, counting the hours and so forth. So it's from a family's perspective that's stressed out to begin with, dealing with the caregiving issues, the financial issues, the emotional issues. having that type of assistance is certainly something that we pride ourselves on, and we're grateful we can provide that service just because it's needed. All right, so if we're going to move on to another question here. So during the pandemic, right, the idea of a Medicaid recertification was put on hold. Now these recertifications are back up, right? They're being sent out to families. We're working on them. We're submitting them. The families are working on that. The concern, though, is there could be changes to income, right, Dennis, during this process. And unfortunately, just working through the Medicaid process, it's taking some time for the approvals to come in on the research. So Dennis, talk a little bit, please, about the delay and what that may mean as far as a client's income and their pooled trust deposits and so forth.
Right. So what happened is last year we had a significant increase in the amount of the income that a Medicaid applicant was allowed to have. It's a big jump from what they previously were allowed. So therefore,
Right.
the spend down amount had dramatically decreased. Now, when you do a recertification, that will be taken into consideration. And they'll lower the spend down that has to be put into a pooled income trust or paid directly to Medicaid.
Yep.
So if the research are being delayed, you could have consumers putting too much money into a pooled income trust or paying too much of an overage to the county to get Medicaid services when they don't necessarily have to. So then the question we're going to pose to Jim today is, in that process, because I understand the counties are really overloaded with doing recertifications. There's a big backlog of them, so it could take more months than it used to. What do we do in the meantime? If someone has a dramatic decrease in an overage, can they, as long as they're accurate with their figures, can they start putting less money towards that spend down, towards a pooled trust, or paying the county less money? Because if once they finish out the recertification, it'll go retroactive anyway. Can they start now so they can save those dollars, is the question.
Sure. Okay. So just to recap and add in a few things that I want to make sure put people's minds at ease. Yes, we are flooded with renewals because it's been back for a year now, and I actually was just looking at that this morning. This is our 12th month now. We have hit a full year of renewals that have gone out. And yes, we are backed up with processing those renewals, but just so everyone is aware, in case anyone panics or hears anything, goes, oh my gosh, I'm going to lose my coverage. You're not. The state is extending coverage for any case for which we have not closed it for not returning a renewal. So as long as we have the renewal in-house, the state is going in and extending and making sure that no one loses their coverage while we process those cases. So if anyone's out there listening thinking I better call to make sure, you're fine. You're really fine. It's been seamless, and then we always have a hiccup here or there, but it's really okay. The other thing I want to point out is the state, when those income limits changed, there was correspondence that went out to consumers to remind everyone, if you had a change, if you want us to look at your case to rebudget and make sure that if your eligibility changed, your spend down decreased, because it did for many people. Something went out telling you to do that, and a lot of people took advantage of that. If you didn't, and you're sending in the renewal and there is a change, yes, we will look at that and we will go back where we need to go back in time to adjust your eligibility. So if your spend down did drop and needed to drop a year ago, we can do that and we can make that adjustment if you paid it. If you didn't pay the spend down, and it doesn't really matter to go back in time if you didn't need that coverage. But to Dennis's question about reducing what you're putting in a pooled trust, the important thing he said was, as long as your calculations are correct. I can't, in my capacity as the Medicaid director, tell you or anyone, go ahead and figure out yourself what you think you're going to owe for Medicaid, and you can make that change accordingly. But I do agree that if your calculations are correct and you know that on good faith you're not going to have a spend down, or your spend down is going to drop, that's not going to be detrimental to you. You'll have put in what you need, and that's okay. We'll adjust accordingly when we get to it. It's really not an issue,
Okay.
but I can't encourage that because it makes me a little nervous. But if Dennis knows your numbers, you're good. He's good.
Agreed. All right. So it does sound like, as you just said it, that there's, as long as it's done accurately, the family can undertake that reduction into the pooled trust deposit. Okay, as long as it's accurate.
And as long as the coverage is already there. So generally speaking, if you've provided proof that you're putting money into a pool trust, we give you that coverage for the cycle. So if you have that coverage, and we're not asking you to provide another month of proof in order to give you that coverage, you're fine. If you make that adjustment and we see that you were right with it, then you covered yourself. If you need us to put coverage and we haven't recalculated that yet, that could be a bit of a bump in the road, although most likely my staff will at that point take the opportunity to recalculate before we ask you for another month of proof. So either way, it works out and you're fine to reduce it.
Fair. Okay, good. Does that work, Dennis? Right? That does that.
Yeah, that's fair, and it's accurate. To be on DSS is to understand Jim's point, right? If you're wrong, then you'll owe the county. Let's say if your overage was $200 and you said, no, I calculated as 100 and you're actually wrong, you're gonna owe the county that extra $100 if you had services during that time.
So
Or
you're
if you
not going
needed
back. You're
services.
not going back to the pool trust. You're paying the county at that point.
Yeah, you can't put into a pool trust after the fact. So if you're going to make that calculation, maybe pad it a little bit to put a little extra into that pooled income trust just to make sure you're correct. So I wouldn't put it, if you're coming up to $100.03, put in $120 just to make sure. And therefore it'll be fine because you can put extra amount into pooled income trust and you're fine. Putting too little is where the problem comes.
So take that to the next step. So let's say a client, a recipient does not reduce their number. They've been paying the higher amount into the pool trust every month. And then 3 months from now, Medicaid comes back with the rebudget. There's no getting that money back from the pool trust.
No, you can spend it out of the pool trust,
Spend it.
right? But I don't know Jim, there's an important point here. What if they're paying the county their overage and they overpaid for those 3 months? Does the county refund money? Or lower the overage for going forward? How do they do it?
If you pay your spend down and you pay too much, we will either carry that credit forward. If we adjust backwards, we'll carry it forward. If it eliminates your spend down altogether and you no longer have one, there are occasions where we'll just refund that money rather than hold on to it. And then we always have the third option of when we go back each year and do a reconciliation, we look at what claims were paid against what you paid in as your spend down, and you get the money back that way, no matter what, even if we didn't lower your spend down. So there's a lot of ways to get money back.
Yeah, that's fair. That's fair. That's good.
It is good.
Okay.
Thank you, Jim. It's great having you, Jim. It's great having you. So thank you. All right. So the next topic. So while we will do all we can, just like families and colleagues, to keep an aging loved one at home, there does come a point in time where, for some, the need for a nursing home becomes necessary. So if we have a client, a Medicaid recipient within the MLTC program, and then they transition into a nursing home, okay? So Dennis, phrase that or frame that so that we can look at the issues there, because how long is the MLTC involved? What are they paying? What are they not paying? When do they step down, et cetera?
Right, and that's been a constant problem since MLTCs existed. They have to cover a certain amount of nursing home care if you transition. And Jim and I were speaking of this, and we believe it's 90 days. I think it's 90 days. So for 90 days, if you go into a nursing home, you're going to stay there. You would imagine that the MLTC is going to cover you on the community Medicaid services for 90 days. They have 90 days of chronic care Medicaid coverage. But the rule is that they will pay that chronic care coverage for that 90 days as long as you're eligible and applied for that upgrade in coverage. The letters that MLTCs are sending out, managed long-term care plans, are sending out to nursing homes saying, yes, we're going to cover this applicant for that 90 days. Right. So a nursing home is thinking, okay, we're covered for 90 days. So on the 91st day, that's your chronic care Medicaid pickup that I will give to the attorney and you'll apply for chronic care Medicaid. And that's absolutely wrong, because then I'm going for chronic care coverage from the 91st day forward. And there's truly a 90-day bill because I didn't apply for Medicaid coverage for chronic nursing home care until the 91st day. So the previous 90 days are not covered by chronic care. They're not covered by community Medicaid. And they're not covered by the MLTC because once the MLTC figures out you didn't apply for chronic going back to the first day of admittance to that nursing home, if they paid the nursing home, because they're going to continue to pay because they have 90 days, they're supposed to, and then they find out by looking in the coverage that you didn't have chronic care coverage, they roll back the funds to the MLTC and take it out of the nursing homes, so that the nursing home has a huge bill and they don't have the chronic care coverage. So it's this constant mess. And I've seen it so many times over the past, since 2012 forward, I've seen it so many times that I don't really have an answer. And I think it's the fault of the management. It's not the fault of the county at all. It's not a fault of the state. It's the fault of the MLTC by giving that notice that says they're going to cover, but they're not telling you the full story. And the clients get it as well. And they come to us, and they've come to you, Brian, and they say, oh, we're covered for 90 days. I'm like, oh, you're on the rehab. No, the managed long-term care plan is covering us. And when you see it, say, well, that's what they said, but it's not really true. And that's the problem that I come across.
Okay,
So
so
anything you can give us on that, Jim, because I have no idea.
No, well, I mean, yes, I have something, but I think when we discussed yesterday too, the biggest thing to do is to point out to consumers and family members and advocates and attorneys, be proactive, right? So you don't need to wait for the plan or the nursing home to notify social services that you or your family member or your client, your consumer is in the nursing home. Because like you said, if a managed long-term care is sending out a letter that says we're covering, they don't tell necessarily the full story. They're only worried about their we're saying 90 days because we believe that's what it is. So be proactive, let us know. We do not need to start our process. We don't need an official pickup statement form. Dennis is gonna like raise his eyebrows and be like, yes, you do. You always tell me you do. But we can start doing the work and the legwork to get the process started just with notification. All we need to know is the same information that's on there, where they are, what date they went in, and we can go from there to at least get it started. And that's probably the biggest tip I could give for this, because we're not going to change that letter that the managed long-term care sends out. That's now in our purview, but we can get the word out to still contact DSS so that we know this is coming and we can get the work started beforehand. So you don't fall into a crack of no one's covering for that period because you thought someone was going to tell us and nobody told us, and that it's not anywhere we want someone to fall into. We want to get going and be proactive on the
be
coverage.
proactive. That's the answer there. All right. Understandable, because there is often clients are coming in and families are coming in, again, stressed about a number of things and not necessarily recalling everything they're hearing, but they're saying, oh no, this is being covered. Still be proactive, get the ball rolling. 100%. Agreed. Got it. All right. So we good on that one, Dennis?
Yep.
All right, great. Agreed. So moving on to our last topic, and then we'll open it up for questions. And again, those of you that are watching this with us, if you have questions, get them into the chat box, the Q&A box, and we'll answer them as we go after this. So the idea of paying for long-term care in general, Jim, when we're talking with clients, we'll share, you can always pay for the care yourself if you have sufficient ability and funds to do so. Or there's Medicaid to pay for it upon eligibility and application and approval. But there's also in there the idea of long-term care insurance. And I wish more people had long-term care insurance, and I wish that they had robust enough policies to actually pay. I'd say maybe 10% of our clients actually come in with a policy, and then maybe half of them, if not less, actually have enough to actually pay for the care, which is a whole nother educational component. But what we're looking at is in a home care scenario, and we've seen this, Dennis has seen this, the payment of benefits to the family. So if it's X amount of dollars each month payable to the family, how that's being treated, how that's being budgeted, it's supposed to be paying for certain care. Medicaid's the payer of last resort. So it's gotten a little sticky in there, and it's certainly a topic that Dennis wants to kind of clarify a little bit, right? So Dennis, kind of share a little more detail if you can with Jim.
Right. So right now I have a current case, not Suffolk County, but I have a current case where there's significant long-term care insurance benefit. I think the benefit is about $6,000 a month. Medicaid just budgeted it as income to the applicant. So let's say if they had $7,000, they have $1,000 in Social Security, so they have $7,000 in income. And the long-term care benefit is being paid directly to a home care agency, so the applicant's really not getting it. The county still budgeted as income to the applicant. So there's two problems here. The home care insurance, the long-term care insurance is not being paid to an agency, number one. Number two, the applicant is keeping the money, putting it in a pooled income trust, therefore making Medicaid the payer, not the last payer, last resort. They're actually paying before the long-term care insurance. Long-term care insurance doesn't get paid to the home care agency, and the applicant gets to put it into the pooled income trust and use it any way they like, as long as it's for their benefit. So it's a problem.
Yeah.
And now that's if they got the check directly. If they didn't get the check directly, it's going directly to home care agency. How can they put $6,000 into a pooled income trust that they don't have? So therefore, they can't possibly meet an overage. So this is this constant back and forth we have with long-term care insurance. Now, if it was a robust policy, like Brian said, we wouldn't be applying for Medicaid and we wouldn't have this problem. But most people don't have that, unfortunately. Right. And home care expenses have gone through the roof. So there's a whole budgeting problem too, and there's a whole nursing problem. Like where, if you're getting $6,000 worth of services, where does Medicaid come in and say, okay, we're going to provide that extra hour, or no, your $6,000 worth of service, you're getting 6 hours a day. That's all we would budget anyway. We're going to walk away from this. Right. So it's a problem on multiple levels, from the nurse division and from the eligibility division and budgeting divisions. So right. That's the issues that I have with it.
And just to put a little final twist on it there, the insurance is meant to be paying for the care. And if it's not paying for the care and it's being treated as income, is that insured now in violation of what they're supposed to be using the benefits for? You know, does that open the door, or is there any risk for them there? I think there might be. Yeah. But Jim, if you can comment on long-term care insurance and how you see it or how you think it should be, et cetera.
Yeah, I have a few things on this. So first, I can verify it's wildly underutilized because I can tell you right now, in my early days as an examiner myself doing this job, I never saw one. I never saw one. It only as I became a manager and now took over this role and moved up, we start to see them, and we really saw them so infrequently. My own staff just was like, what is this? Every time you got one, it was a little different. And they are very different. So the short and simple breakdown of how this is the last time we asked the state how they advised us, which is what we should be following. If a policy is assignable, so if the money for that insurance that's supposed to go to pay for something can be assigned to pay directly to that provider. So if it's supposed to cover home care, and instead of the money passing through the consumer or the policyholder, it goes straight to that agency to pay for that home care, then we do not count that as income, because it never, and this is kind of the general Medicaid 101 rule for how we count income in general. If you never put your hands on that money, we don't count it as a general rule, right? So in that instance, we would say assign that to the provider, or sometimes the policies are more general, right? The provider goes to the insurer, just like a regular insurance, and it gets paid, the bill gets paid. Then we're not concerned with it. We need to know about that policy because we're a last resort payer, but we're not counting that as income. Right. If it is not assignable, or it's assignable to the policyholder themselves, that's unearned income. And that's more of the hairy ones where we talk about the consumer may get a certain amount of money from this policy. They may get it based on a bill that they have, but if they touch that money comes to them, then we have to count that as unearned income. So that's money that you received. Theoretically, we don't know whether you use that money to pay a provider. We know that it's for that and it should go to that, but because you touched it, we have to count it. So that's going to be countable income. Then there's the third one, where a consumer pays a bill and then has to submit that to their long-term policy to say, I already paid this, can you reimburse me? That we would not count as income, because if you can show us that you paid a bill and you got money to reimburse you for that bill, that's not income, that's just kind of passing through. We would not count that as income. It's a little confusing, but that's the simplest breakdown. If you touch the money, we count the money, unless it's just to reimburse you something you already paid for.
I have one question to that, Jim.
Go for it.
If they get the money directly and then pay it to the provider or the home care agency, will that offset their overage? Is that going to be seen like a medical bill to offset overage?
It would have to, right? I'm just thinking off the top of my head, because that's, we're counting it as income. But then with an overage in general, you show us that you paid a medical bill, which is what they're doing, then that comes off the spend down. So it does cancel itself out, but
Okay.
we're gonna count it up front until you prove otherwise. So yes.
As a practitioner, that's important for me to know, so I know we're not putting it in the pooled income trust and then
Right.
having the pooled income trust pay the home care agency, because that's just a bigger mess.
Right, that makes it really, really messy. Yeah, no, that's great. And then the last piece I think you talked about was, how does it affect
Yeah, the nursing.
the home care piece? I asked our nursing staff, and I didn't get a complete answer that I really loved on that, but so I'll speak kind of generally. We would take that into account, but not exclude you from, you wouldn't be excluded from home care. When we do the assessment, again, someone's assessment, another assessment, our final review to get the care plan of care.
Mhm.
If, regardless of whether you're paying $6,000 for home care, whatever, if you still have a need that's not being met, we're gonna allow you to have home care if you're eligible for that service. So it really depends case by case. We've had consumers getting services not related to long-term care, but just that they were receiving some sort of private services that covered, the spouse was on a ventilator. We said, well, you're whole with that. However, you still need housekeeping services. That's not covered by that nurse that's doing that. We could fill in there. So we're not gonna exclude you. And I always tell people, just come to us and let's look at it, because why not try for something? If you need more, maybe we can give you that extra
Right.
to fill in what's.
All right, so that's the point. So the take-home message here is, if you have long-term care insurance, don't exclude yourself from Medicaid if your long-term care insurance really is not gonna cover everything that you need. Okay.
Absolutely. There might be a need there, and let's see if
Yep.
we can complete it.
Okay, excellent.
Is there any, if long-term care insurance is covering, let's say, 5 hours a day, and the award for hours is 5 hours a day or less, you're out? You're only going to be coming in if it's greater than what's already being provided by insurance?
It really depends on the services more than the hours, because we've seen cases where they had 24-hour care, but it was limited to, they were doing this, that, I don't really want to say specifics. And
Fair.
we could supplement because they weren't doing, again, I'll say housekeeping. That's the easiest example, is the lower
Sure.
level stuff. They were only focused on this. So they had 24-hour care, and we still were able to authorize more because it was
Right.
focused on other services. To be general, I don't want to give
Got it.
too much
Fair.
about that case, but
Okay.
So adjacent to that issue is when we have a client who's receiving, let's say, 8 hours daily of care, that's how we're allocating it, and there's a need for more care. So Dennis, when there's a need for more care, our advocates, our care coordinators are getting involved, advocating for more care. What does that look like? Is that process one that is on, I'll use quote unquote, on the smoother side because the services are already provided, or are there significant challenges in trying to get more hours and demonstrating a need for more hours?
No, because when you get to the nurse assessment part, the nurse will come out and say, okay, one of the questions when I used to go on nurse assessments, one of the questions was, do you have care in the home? How many hours are you getting now? Then they're going to go through their full assessment, say, okay, we think this case is a 10-hour case or 12-hour case. If you already have 5, we'll authorize. It's going to be an authorization, internally an authorization for the 10 hours, let's say, but 5 already spoken for. So you have, like, in other words, you voluntarily have care, you paid for care, they're already spoken for. So we're going to provide you 5. You're a 10-hour case, but 5 is already off the table because you have some means of getting those 5, and we'll provide the remaining 5 hours. That's the way I feel it should go. And I think nurses would be very receptive to that. You will still get the full assessment. They're not going to start at only 5 hours. No, they're going to do a full assessment. Your case deserves X. If 5 hours were taken care of, we'll approve for the remaining 5 hours, because your long-term care policy could lapse. It could be expended. I mean, lots of things could happen.
Sure.
You don't have it anymore. So, but you're still a 10-hour case. So then they can say, well, the voluntary care, if spouse was helping you or a family member was helping you, or your long-term care insurance care has expended, we look back, oh, you were always a 10-hour case. Now you can get the full 10 hours. Medicaid will pay for the full 10 because the other care is gone.
Right. Understood. Fair.
And
Okay.
it's distinguishing between the assessment and the plan of care. What we assess you at, or what someone
Right.
agency assesses you at, is different than the plan of care. You'll be assessed for 12 hours. You already have 7. Your plan of care will be for authorizing the 5 that you need.
Yeah.
So it
Fair.
Yeah, I think that would be, to your point, Brian, I think that would go smoothly. I do think it would go smoothly.
Good.
I do believe that.
Good. We've covered, well, time limitations, et cetera. We've covered our substantive points that we wanted to cover. So let me go through the questions. As I'm looking at that, Jim, is there anything else you wanted to share? Any other points or updates that you wanted to share that we didn't touch upon?
I'm looking at my list in front of me now, and I think I touched on them because they kind of somehow came in with some of the questions. So just reiterating, the unwind, which is the recovery from the public health emergency, has been extended through 12/31/24. It was originally set to expire after 12 months, which would have been this coming month. It's been extended. So that's great. So that's the biggest one. I think everything else we
Which
touched
then
on. So
pushes
that's-
the look back, the home care look back.
which
to-
we believe will push at least into 2025.
Got it.
Unless they shock us, really. I'd be shocked.
Okay, got it. All right, so just housekeeping question. Is the webinar being recorded? Yes, this webinar is being recorded. All of our webinars are recorded. We will then email out a link to those that have registered. It's also on our website, tullyelderlaw.com. You can find the webinars there. They should be up within 24 hours. What is the number to call to schedule a home care assessment? I don't know if we can answer that right now, or can we? Do we have access to that?
I should, and I'm waiting for someone to write me back so that I can tell it to you, because I don't have it in front of me at the very moment. And normally I would yell out to my clerical staff to ask them. So we'll have it by the time we hang up.
Thank you. All
Brian,
right.
one thing I think we should do is because there's an update. We didn't list the limits for resources and income for this year, because they did go up again. So it's
Perfect.
important.
Go ahead.
Just take us, 30 seconds to do that. Just so everybody knows, if you're on home care Medicaid and you're a single person, you're allowed to keep $1,752 of income. That includes a $20 household disregard. If you're a couple, that goes up to $2,371. Okay, for a couple. That means anything over that money, what they do is take your gross income, minus out what your health insurance is, and the remainder of your net income. If it's $2,371 or less for a couple, you don't have a spend down or an overage. Anything over that is a spend down or overage and go into a pooled income trust, pay a medical bill, or be paid directly to the county. For resources for a single person is $31,175. That's a lot of money. It's a big increase from a couple of years back. So that's what you're allowed to have as resources. Does not include IRAs, because IRAs got to be put into a payout status for Medicaid purposes. For a couple, you have $42,312 is what you're allowed in total resources for a couple. So those are important things for community Medicaid, because we're focusing on that right now. The nursing home limits are still $50. And there's a community spouse income allowance. If your community spouse makes less than $3,853.50. There's enough income from the institutionalized spouse can be transferred to the community spouse. So that's important to know those values. And I guess we lost Jim because he's probably getting that. Oh, there he is.
He's yelling across the office.
I was not yelling, but yes, I was working on that.
Okay, got it. So did you get an answer, Jim, or no?
Nope, let's move on. We'll
You
get
got
there.
So a question. Once DSS receives the NYIA, the NIA approval to move forward, does the client need to have the consumer-directed, the CD Pass physician's orders completed within 30 days for the DSS nurse to go out and assess for hours? That is a question from Kim.
I don't know. I think that's confusing. Because that 30-day, if this is the order she's speaking of, that's the physician's order that used to be good for 30 days. That's no longer necessary. They go with a different doctor's order. It doesn't have a 30-day expiration anymore.
Got it.
So that doesn't work that way any longer. The 30-day I believe it's the 30-day form that used to fill out, a doctor would fill out and complete a 30-day a review of you. That's no longer necessary because NYIA is doing the review. So the doctor's order now just states, yes, this participant would be eligible, would benefit from having home care assistance. I believe that's what it is. Jim, do you have another take on that question?
I'm glad you knew that much because I don't know for sure, but I do believe that time frame has faded in
Yes.
with the
Yeah,
change
it's
to the
not
NIAP.
necessary. Right. And it wasn't particular just the CD pass anyway. It was for any home care. It was immediate needs as well.
Right.
Okay, someone says MLTC, Managed Long-Term Care Plan. Next question. That's what that stands for. That's New York State is a Managed Long-Term Care Plan state. Community Medicaid services are provided through a Managed Long-Term Care Plan. They're a partially capitated program that the state contracts with. They're like modified insurance companies in a way.
Interesting. Can you comment on what is called short-term LTC? Is that a
Yeah,
phrase?
that's in a nursing facility.
That's what we were getting
That's when
earlier.
I'm believing that's where that term comes up that I know it is when you're in short term. You haven't converted. That's your rehab stays in a nursing home. It's short term care.
Mhm.
That's the way I know it. I don't know. Maybe if Steve, you have another comment on that. I don't know. I think that's what you mean. But I don't know what you want to know about that.
Right. Okay. Is there a conversion agreement necessary to execute in order to transition to a nursing home? Is there a conversion agreement necessary? I guess from MLTC to nursing?
No, well, how you would do that is for Medicaid purposes, you have to give a supplement A. You have to fill it out completely because that's your 5-year look back. So that's a conversion when you're going from regular community Medicaid to nursing home coverage. And of course, you got to give the 5 years worth of bank statements and financials. The conversion agreement, now in a nursing home, you have an application agreement to apply to get into a nursing home. They have to have their residential application that you're going to apply. You want admission into the nursing home, so they have that. But I don't know of any other agreements that are necessary.
All right. And then we have more of a factual question. Dad is 94 in rehab, coming home soon. How do we get PT and aid during the day? And that's going to be through our CHA services. That's going to be after discharge. And that's to be arranged at discharge, right, Dennis?
Yeah, basically you're going to get a community home health aid. It's called a CHA. It's covered by Medicare. They give you very limited PT services, very limited aid services, which I think for the most part have dried up over the past few years. I haven't seen many people be able to get a home care aid through Medicare. And the PT services are limited. They come out for a couple of visits, maybe up to 2 weeks, and then they fade away. So that's Medicaid is the way to go for if you're going home care for any particular amount of time. And 94-year-old, I would imagine you're going through. You're not going to get much from Medicare. You're going to have to do Medicaid. Benefits from the VA are just going to be your aid and attendance benefits, and they're always a nightmare to coincide with Medicaid. That's a constant fight with Medicaid from my perspective, because how do you get aid and attendance if Medicaid is paying for your aid in your home? And then the VAs, they want to know when in accounting what you did with the money. And if you have Medicaid paying for home care, they can say, well, then you didn't need the money. Sometimes if you're going to a Medicaid, not even a Medicaid, assisted living facility, you could still get VA benefits because they're being paid for the rent, and then you're getting assistance or whatever, you're paying towards that medical bill or that medical expense, which would be assisted living from the VA's perspective. Nursing home, you're not going to be entitled to more than $90. Unless you're in the United States Veterans Home, which is a whole nother topic. And it's a longer discussion. So the benefits, if you don't want Medicaid, you can go to the VA and they're going to be maximized out for a single veteran to the tune of around $2,100, I think, a month. That's about it, but that's not going to cover much home care. Home care now, if you need a significant amount of hours, if you need, 8-10 hours a day, it's going to cost you more than $5,000 a month. So it's not going to really get it done.
So generally, Medicaid is a better
is the way to go. Sure.
than VA for sure. So going back to the MLTC and transition into nursing home, the question is, why doesn't the state or county amend the form telling the recipients that it's covered for 90 days? I mean, is Something, Jim?
As Jim says, the state has no control really over what the MLTCs are putting out. If that document that they have is wrong, it's not like the county can come forward and say, okay, MLTC, you wrote this wrong, please correct this. Sure, could the state get involved? Possibly. But if the idea of these Zoom meetings is to alert and tell people, okay, if you have this problem, like Jim said, tell Medicaid. Medicaid is the person who's paying. The agent, the MLTCs are the agent of Medicaid. Now, granted, it's not a great system because there are private entities. So if you know there's a problem, get involved and don't wait for the problem to happen. Alert Medicaid, say, listen, I'm going long-term, or my dad or whatever's going long-term. What do I do? What's the next step? Just so you're covered. Don't bank on the fact that, oh, MLC, I caught you, you did something wrong. The only person going to get caught is yourself. It's just not worth it. It's just not worth your aggravation. So, Jim, that was a very good advice from Jim, and just let Medicaid know and they'll walk you through the process.
That being said, I did take that and write myself a note to just send that on to the state, because while I don't hold contracts with those MLTC plans, so I can't change what they put in a notice, I can easily pass that on to the state to say, hey, maybe you should look at the noticing that they give a clearer message. Whether it gets heard and adapted, I don't know. So I still say be proactive, but thank you for, for pointing that out, because it can't hurt to ask, right? To make them do better.
Next question. When did NIA, that New Yorker Independent Assessment, come into existence? What year was that?
Okay. That just happened. That was 2022, I believe, because we had Maximus before that. Maximus did a similar thing. They assessed to see if you qualified for home care assistance, and they were replaced by NIA. When NIA came along, that 30-day form that someone else mentioned went away with it, because NIA is the actual physician's assessment. So there's no 30-day requirement anymore. It's just your physician form has been reduced to, yes, this consumer would benefit from home care assistance. So they have been, but the idea of Maximus has been around for years.
All right. So another question is, sibling is on long-term care, no picture ID, can't go to DMV. How do we get picture ID? Can it be waived by Medicaid? Is there something else that can suffice?
I don't know, Jim, you can comment on this. I didn't know you needed a picture ID to get Medicaid.
We don't, because technically there's a requirement for identification for Medicaid eligibility. However, if the social security number is included on an application, that's going to get us verification of identity. And there's multiple other ways we can verify identity. So we do not generally need a picture ID. I never say never, because I'm sure someone will come to me with some weird example where we did, but generally speaking, no, we don't need a picture ID or an application typically.
If one of the last questions here, if the look back is in fact implemented for home care, would NHTD be exempt from the look back?
That's a good question. Nursing home transition diversion waiver has its own set of rules. I would imagine those rules would remain what those rules currently are, but I don't know. We have not gotten guidance on the details of how this look back could look. So
that's part of the, they haven't gotten to it yet. So maybe that will come out once, if they start getting to the point of regulations. Got it. That's for planning. Irma, the question, amendments when moving to another state. So on the estate planning side, yes, right? You always want your documents to be relevant to the state you're in. But on the Medicaid side, it's entirely different state to state. So if somebody does move, you're basically starting over. Next question, when applying for Medicaid, does it matter if the person has Medicare, traditional Medicare, or one of the Advantage Medicare insurance plans? It doesn't, right?
We just need to know.
Just need to.
You need Medicare A and B, though. That's what you need, which the Medicare Advantage plan, you have both, but you need both A and B. Yep.
All right, then as far as contacting with us. So first and foremost, Jim, I want to say thank you. We've gone a little bit over. You've been wonderful once again. Look forward to our third annual next March or April for more answers, more detail, and more of an update. Dennis, thank you as well, as always, for your expertise. Is there anything else you wanted to share, Jim?
Just that I did answer in the chat the phone numbers for our intake in our nursing unit. I answered it, so it popped up under the answered questions. I'll just say it in case anyone can't find it. I have two numbers, 631-854-9585 or 854-9834. Those are our two local numbers. We may refer you to NIAP, but call us and we'll get where you need to go.
Very good. Very good. And so Dennis and I are partners here at Tully Law Group, and Jim is our guest, of course, from Suffolk County Medicaid, the director of Suffolk County Medicaid. We are tullyelderlaw.com. The office phone number is, as it was asked, 631-424-2800. 26 years we've been helping families navigate the elder care and all the estate planning concerns that they do have. Our website has a significant amount of webinars that we've been hosting back since the beginning of the pandemic. So if you want to get a little more information, you're certainly welcome to come on in and talk to us, or you can check out the webinars and videos that we have on the site. Again, Jim, thank you. And all of those that joined us today, it's been a pleasure. Thank you very much. And let us know if there's any questions. All right. Thank you again. Bye, guys.
Thank you.
Bye-bye. Be well.